Welcome to Gas, the true story of a toxic train derailment. I'm Ron Scholl. Last time on Gas, the only case to try Montana Rail Link for liability over the Alberton derailment and chemical spill pit plaintiff Sam Austin against MRL and Burlington Northern. At stake was also MRL's negligence and potential punitive damages. The outcome will likely affect all remaining lawsuits. We now continue with Part 6, Chapters 23 and 24. Chapter 23, Endgame. The coverage of this story has been incredibly poor in my experience, Ted Lyon bemoaned in his hotel room prior to working on his closing argument. The press, it's hard to even get them to deal with you. This is a pretty interesting thing. It's like they are afraid of it, or somebody's got their thumb on the editor. The Missoulian had almost ignored the Alberton spill lawsuits, just as they had ignored EPA Ombudsman Robert Martin's investigation prior to the 2000 hearing. Their editorial after the spill served mainly to praise MRL, while they paid scant attention to victims' complaints of chronic illness. Lyon had interviewed with the paper in September 2000 before a trial date was postponed, but no litigation story ever came out. Lyon's assistant, Michael Yesasaga, talked to Missoulian editor Mike McInally and felt they were minimizing these people's injuries, he said. He just more or less blew me off. Lyon said, "We've been here 2 weeks now, and they are really writing some good editorials about the Libby problem with those poor asbestos victims. And this is very similar to that, and they won't even write a fair story." Even their reaction on this trial has been poor, Lyon said. They are very slanted toward MRL. Lyon noted that a local murder trial received daily coverage, while the paper ignored any lead-up on the only trial over MRL's liability for the Alberton catastrophe. Once the Austin trial began, reporter Mick Holian briefly covered part of one day's plaintiff questioning during the first week, reiterating old misinformation that 4 chlorine cars had leaked. Holian referred to the FRA and NSTB investigations that an internal split caused the derailment, but neglected to mention their conclusion of rail wear as a factor, framing rail wear only as a plaintiff claim. The second week, the Missoulian briefly reported on Sam Austin's claims of aggravated asthma since the spill, and MRL's claims that the failed rail had earlier passed all safety tests and inspections. The only other mention of rail wear by the Missoulian came during its belated report on sanctions against MRL in the Schlepp case in 1998. In court, Lyon was emotional at times. Privately, he was angry. "This, to me, has been a cover-up from the very beginning," he said. "And the longer we get into it, the more we find out the more of a cover-up it is." Lyon said MRL had controlled the scene, keeping out the EPA, until day 4. He called the situation unprecedented manipulation. Lyon was angry that State Court Judge McLean had excluded mention of exposure to other chemicals, but he hoped the Montana Supreme Court would overturn this and other decisions. "Something else that we've discovered that I think is very interesting," he said. "MRL originally got all these doctors convinced that this chlorine couldn't cause you to have any permanent problems. They've got them now as experts testifying for them in the other cases. You know, this whole thing is that well orchestrated by some very powerful people. Well, these people have got kids that were exposed to this stuff, and they've got kids that are real sick. It's a bad thing," Lyon said. Lyon said MRL had spent over $1 million just on experts alone, $1,300,000 that we know of. Lyon had won against some big names, including the infamous Koch brothers, but this case was a different animal. If you could get this corporation into a fair fight somewhere, and not in Missoula, Montana, you could really hurt them, so to speak. But they are a big-time employer here, and it's hard to fight, Lyon said. But the game for MRL is to put up all these obstacles, wear us down, spend all this money, and thank God I'm a lawyer that has a lot of money to fight these people, because if they didn't have Grady and I, they wouldn't have a case. On liability issues, Lyon thought the disappearing rail with an A brand and a vertical split head very suspicious, he said. If we were anywhere but in Missoula, Montana, they would be really hurting because of that. Judge Erickson's rulings had made his liability case difficult. A lot of the stuff on preemption, it's not as preemptive as he says it is. Just like those FRA standards are minimum standards. Minimum. He will not let us say that. He says it's preemptive. Lyon slapped his hands. Therefore, it's nothing. This issue mainly had to do with frequency of track inspections. Lyon, they want to instruct the jury, MRL does. We can't win our case on worn rail. We can't win our case on A-rail. So what's left? Failure to inspect? That's what they say. We may have to appeal this because we think if the judge gives them this that he's going to be way wrong. The MRL lawyers, I think they're intellectually dishonest. But it doesn't matter because if they screw us up here in the trial court, then we will have to appeal it and it'll be 2 years down the line. And they're going to make tons of money on it while they're doing it. And eventually, maybe these people will go away, they're thinking. Maybe their lawyers will go away. Lyon said MRL had a game plan that has just been a litigate scorched earth policy. And the reason being is that they want to wear these people out, wear them down. And they're doing that with some of them, quite frankly. Some of them are about to give up. I think this trial has given a lot of them a lot better feeling. Because at least they see that somebody has got the guts to go try these guys. You know, Lyon concluded, this is one of those kind of cases we could work on forever. For Sam Austin, after 5 long years, the reckoning had come. In his closing, Lyon emphasized that the case was bigger than Sam Austin, that the decision affects everybody that lives along this railway, a decision that would determine the standards of safety in Montana regarding toxic spills. Lyon became emotional as he asked the jury to send a message to MRL that you are not in your dream world anymore, where standards are standards and rail could be worn to a nub. Preponderance of evidence meant a mere grain of sand on the scale of justice, Lyon said. But in raising the question, was MRL negligent? Lyon referred now not to the evidence, but to Dan Watt's admission of responsibility. Forget the rail experts, Lyon said. Combining all damages, Lyon now suggested over $1,800,000 in compensation, about $100 a day for the rest of Austin's life. Lyon had originally sought $2.5 million in damages. MRL had offered $200,000, which Austin turned down. Finally, Lyon ran through the timeline of MRL's safety record and track history leading to the Alberton derailment. How many more warnings should they get, he asked. The next warning, ladies and gentlemen, should be from you. You're going to set the standards. Lyon had anticipated David Potter's closing when he said this case was not about individual employees, whom Lyon called good people, but the corporate mentality of MRL. The first thing Potter said in closing was, we all have jobs. Sometimes we have to stand up to be judged on how we've done. Instead of Montana Rail Link, Potter named Augie Cantu, Earl Perrine, and Roger Babcock as those who are on trial here, over Lyon's objection. Potter next logically took the jury through his arguments step by step. He summarized how MRL had complied with all track inspection requirements and claimed the vertical split head was non-detectable. If there was nothing there to be seen, he said, the inspections did not cause the derailment. Worn A-rail was not a reportable defect, and Potter dismissed other track conditions as factors. Randy Cox closed for MRL on damages. Watt's public statements had nothing to do with liability, he said. During evacuation, MRL took care of people as a responsible party should take care of people, he said. Cox said that all of the plaintiff's emphasis on liability, while MRL admitted the derailment had harmed Sam Austin, tells you something, insinuating that the entire trial was about seeking higher compensation. Also tellingly, MRL made no such admission until late in the trial. In his closing, Lyon had asked the jury to silently reflect for a minute on Austin's experience in the gas cloud. In a risky move, Cox now recalled that Austin was in such a hurry that he refused to stop for a man, Lester Miller, stranded in the chlorine cloud, and drove off. In Lyon's minute, Cox said, Austin could have done something for that man. With that mood set, Cox took the next step and called Austin greedy. Asthma was common, and medications gave quick relief. Selfish and greedy. There is one thing that sets him apart from other asthmatics, Cox said. That is money. He wanted money, and quite a lot of it. This case is about money, Cox said. Cox suggested that the jury compensate Austin something for 2, possibly 3 years' worth of tuition, books, and room and board. If you think $15,000, $20,000 a year, I don't know, Cox said. Get him a start and get him going and move on with his life. On behalf of MRL, Augie, Rich, Earl, Roger, we ask you that the damage figure you place on that line be fair and reasonable, Cox concluded. Having impugned the motives of Austin, Cox closed with an appeal on behalf of the hometown folk. Lyon gave the final closing statement, noting that only after 5 years did MRL finally admit responsibility for Austin's injuries. They thought they would starve this kid out, he said. He called Cox's remarks about Austin not stopping for the man in the gas cloud a cheap shot, considering Austin had his 14-year-old cousin in the back seat. As for the rail, he said, the story's in the metal, but not their story. He called the gathering of the MRL rail experts in 1998 at Broken Arrow a meeting of the cover-up men in which the non-bonded area was discovered. This is when the lawyers take over, he said. This is their story then. Hamstrung by preemption, Lyon argued the evidence wasn't just about worn rail and A-rail, but also inadequate inspections, rail fatigue, rail life tonnage, structurally unsound rail, declining superelevation, and the circumstantial evidence of Keller's memos. All of this, Lyon pleaded, suggested a big combination of track conditions that required remedial action per FRA requirements. The talking was over. Cox was right that the case, in part, was about money, but so was Lyon in pointing out that MRL, quote, spent a ton of money to keep from being accountable. For the victims, the case was also a matter of justice. In terms of MRL's liability, the victims of the Alberton chemical spill concluded their only day in court. The wait began for judgment on Montana Rail Link and Sam Austin by their peers. Chapter 24. Verdict. The jury had 4 questions to answer. Was MRL negligent? Was Sam Austin injured? If MRL was negligent, was this the cause of the injury? If so, what was the compensation? On the 10th day of proceedings, prior to closing arguments, Judge Erickson gave the jury some key reminders for deliberations. Erickson instructed that worn rail and A-rail were not FRA reportable defects and therefore could not be a basis for negligence. However, a combination of conditions may require remedial action and therefore may be evidence of negligence. But without explanation, Erickson excluded, quote, worn A-rail in any such combination. MRL had complied with the frequency of FRA required inspections, but evidence concerning inspections at a speed to allow compliance could be evidence of negligence. The vertical split head was an FRA reportable defect, and whether MRL knew or should have known about the vertical split head could be evidence of negligence. Montana law required a unanimous verdict. In awarding reasonable compensation, punitive damages were off the table. In the Austin trial, negligence and damages were wedded, a marriage not clear to the jury. With no automatic liability under Montana tort law, while MRL could concede Austin's injuries, they could avoid paying damages if negligence were contested and not found. With only a mere grain of sand needed in the preponderance of evidence, Lyon was only slightly worried before his closing that Austin could end up with nothing. I'd be surprised, he said, but I've been surprised before, so these Montana jurors, they're not very liberal in damage awards. They're pretty penurious. An observing attorney commented that the whole process came down to whether or not the jury liked you. If they did, they would find a way to give you money. Based on his reading of the jurors, Lyon said, I think the jury's been with us so far for a good while, and I think we've got some pretty sophisticated men on there. However, from the written jury instructions, the linkage between finding negligence in order to award compensation did not seem clear. The special verdict form read, 1. Was MRL negligent? If yes, go to number 2. If no, go to number 3. 2. Was MRL's negligence the cause of injuries or damage to Austin? 3. Award damages. Answering number 3 was required, leaving the impression that damages would be rewarded regardless of negligence. Malloy had earlier written in Austin that until the Montana Supreme Court ruled on issues such as strict liability, as they might in the Griffin cases, I may consider a jury verdict form whereby the jury would assess damages even if they do not find negligence, to avoid a new trial in the event the jury were to otherwise find MRL not liable. But Malloy had muddied the waters. A local attorney familiar with the case, John Hart, said the verdict instructions were a bit unusual. Normally when you don't find negligence, you stop with that question, he said, and you don't go any further. But evidently, the judge and all the parties agreed that even if the answer is no, that they would want to know what the jury is going to award if they had answered yes. I know the plaintiffs wanted to set a sort of benchmark for what this type of case would be worth, and probably would be able to use that in subsequent settlement negotiations. I asked Lyon before his closing argument if he thought the jury understood the linkage. They won't know, he said. I hope they'll figure that out. So the judge might not instruct them on that? No, he won't do that, Lyon said. Lyon was confident the jury would find MRL guilty, but said he would make sure the jury understood the linkage to giving Austin compensation. However, it didn't seem that Lyon made that point clear at all. Unlike Lyon, Hart thought the significance of the instructions should have been made crystal clear to the jury by the judge. Although, he said, I don't know when that was made clear to them. I sat there in the courtroom that Friday when they read jury instructions. So did you, and I didn't hear anything about that. In his closing arguments, Potter recounted the jury instructions. Was MRL negligent? Was MRL's negligence the cause of Austin's injuries? What was the amount of compensation? Notably, Potter told the jury that this last question stood on its own. You'll have to answer that anyway, he said. Falsely, the jury assumed Austin would receive the amount they awarded. As the jury retired to deliberate, MRL's whole defense team immediately left the courthouse, much to the surprise of Lyon. His team stayed and waited, along with Austin and a few other clients. Mark Hansen, Lucinda Hodges' husband, cracked a joke in the lobby. Know how copper wire was invented? 2 lawyers got a hold of a penny. Yeah, but that was back when a penny was worth something. Sometime during the afternoon, the jury foreman came out and asked the judge if they could award punitive damages. No. Was that question a good sign, Hodges wondered? Did they want to give more? The foreman later said it was unclear to the jury that punitive damages had been taken off the table earlier that week. The jury had been excused during Erickson's ruling. More muddy water. Only after a few hours, the jury was ready. All parties returned to the courtroom to hear the verdict. Turning aside, Lyon growled in a whisper, God damn it, and threw his pen down. Lyon then had the jurors polled. Every single one, not negligent. Sam Austin recalled Lyon saying privately to him something akin to, I hope those assholes never get caught in a chlorine cloud. I was frankly surprised, as were most people I spoke to, John Hart commented. I just sort of figured that the jury was going to find a way to award somewhere between $100,000 to $200,000. I only spoke to a few MRL-affiliated people, but they seemed surprised too by that. But the jury apparently liked Sam Austin well enough. They awarded him $262,000, or so they thought. Tom Barshaw of Trout Creek, the jury foreman, said it was unknown that a finding of not negligent meant no compensation. They had intended to award damages to Austin immediately. Jury instruction number 29 said to award money if Austin was found permanently injured. Well, Barsha said, we found him permanently injured. Nothing said specifically, if no negligence, plaintiff gets no award. Barshaw said if the jury found MRL not negligent, they were to proceed to question 3, and they awarded him some money for college, for his medication, and we all felt that's what he would get. And when I found out later that night that wasn't the case, I had a sleepless night, of course. And I'm sure there are several other jurors that have no idea this even took place. It also hadn't been clear from Lyon's closing that a finding of no negligence meant no award to Austin. If he would have said that he'd get absolutely nothing and made it perfectly clear, Barsha said, I think I probably could have convinced the jurors to find them negligent in not putting a slow order out, that they were negligent by not repairing the rail right away. I lost sleep at night on account of that, trying to figure out why in the world they would not try to make something like that clear to the jury. We all felt that he should have something. He drove through the gas cloud. Barshaw also thought some witnesses were not truthful, but he wouldn't say who or about what. He questioned how well the high rail inspections were done. But mainly, he felt that Curve 155, once on the relay list, needed a slow order or emergency repair. I was the only one that thought that Montana Rail Link was negligent, he said. In the beginning, I felt that Montana Rail Link, the least they could have done or should have done was put out a slow order on that curve, because the curve was worn down past their standards. But he was the only juror who felt that way. Originally, yeah, he said. And there was more that were kind of on the fence there. Well, I'm sure probably everybody would have changed it, because they all wanted to give Austin something. Yeah, I mean, the kid drove through the gas cloud. Regardless of whether it was a negligent wreck or not, still, it was their gas cloud that he drove through, and somebody should have been responsible for that. Despite finding MRL not negligent, Barshaw said if A-rail or worn rail or both combined had been allowed as a cause for negligence, that could have changed the verdict. It probably would have, he said. We might have been able to get more people on my side in the beginning there. I don't think A-rail was a problem. The worn rail definitely was with me. Even though they didn't have to legally, I thought they were negligent by not putting a slow order out on that. Once that rail was worn down below their standards, which are some of the lowest in the industry. They should have put an emergency order on that and got that rail replaced. Barshaw felt the arguments on both sides made the case pretty close for him, though for other jurors, he said, I think there were some that might have been pretty bored with the whole thing. Part of the problem was the technical rail information and a jury perception that one of the plaintiff experts was a know-it-all. While Barshaw thought some jurors agreed that MRL should have done more, others seemed just dead set against giving the poor kid anything, he said, contradicting his claim of unanimous support for Austin. So there was give and take on both sides there, he said. I don't know if it was somebody that had to work for everything they got in their whole life, giving someone else, the silver spoon. Even though that somebody else had suffered a toxic gas cloud? Even that, Barshaw said, that's absolutely. Barshaw ran into Lyon the evening after the trial at a hotel bar when he first heard that Austin would get nothing. Ted told me that evening that the jury instructions were, I think he described them as a jury trap. If so, Lyon failed to spring the trap. The thing of it is, we all sat there for 2 weeks trying to come up with a fair and honest decision on this trial, and then to be hornswoggled by a damn attorney on the jury instructions, it was devastating to me. That somebody would stoop that low to do that, win a case over the jury instructions after fighting for 2 weeks. But this seeming sleight of hand appeared to be a judge's decision. Ironically, in a finding of non-negligence, absent strict liability, the blameless victims of the Alberton spill, as Judge Malloy had put it, had no immediate legal remedy. How do you find them negligent if there's no law? Barshaw pondered. We thought we were pretty well going to take care of Sam, financially, and get him a good start through college. Everybody wanted to do that. After spending 2 weeks sitting on a jury and then you get blindsided by something like that, well, what the hell's the use of being here anyway, Sam Austin was frustrated but resigned. You get sick of it, you really do, he said. I just want to get on with my life. I didn't cause this derailment to happen. I wasn't at fault. I've done what any other person who would be affected the same way I was would have. Handled things responsibly and intelligently. I didn't run out there and settle for $5,000, the going rate he'd heard, which would have been foolish. I documented my symptoms, and I had damages, and I did what I had to do. I had no choice in it. I had to go to court, so I did it. I lost out, but I'm not going to feel bad about it. Austin had wanted to win, but he would accept his health back instead in a heartbeat, he said. Something no amount of money could buy. Meanwhile, MRL rode Cloud 9. Not only had judges thrown out punitive damages, their attorneys convinced the jury there was nothing they could have done to prevent the Alberton spill. Negligence seemed settled for future cases. An ecstatic Randy Cox told the Missoulian that we've always said we couldn't do anything about it. David Potter said MRL's inspections hadn't missed anything that could have been found. Ted Lyon complained that the judge's jury instructions preempting Warren Rail as the sole reason for finding negligence had affected the verdict, and he told the Missoula Independent he was 100% committed to taking this all the way up to the appellate courts. "We want MRL to understand that we're not giving up on these people," he said. The media made no mention of any damage award that the jury had tried to give Austin. Cox later described the jury's mindset thusly to the Missoulian. "Even though MRL did everything they could, they just couldn't see this one coming, and so we're not going to hold them liable." Cox called the jury a pretty intelligent jury, adding, "We've got 7 people fully capable of listening and concentrating and understanding." "There is something wrong there," John Hart said. "MRL is the only responsible party. Sam Austin did nothing to bring this on himself. I think there's a problem with the civil justice system when a company like Montana Rail Link can get off and pay nothing." Dr. Wayne Sinclair termed the verdict O.J. Simpson justice. "It just breaks my heart," he said. "It's really just a perversion." While Austin technically lost his trial, not only did MRL finally admit he was injured by the gas cloud, the jury intent was to award compensation. The legal precedent was set from the Alberton spill that chlorine exposure could seriously worsen resolved asthma and induce RADS and sensitivity to new respiratory triggers. However, no precedent was set for the bulk of reported chronic symptoms among seemingly previously healthy adults, including the broadly triggered and variously symptomatic syndromes of RADS and multiple chemical sensitivity. Another precedent, MRL was not liable for the spill and not negligent. In June 2001, Lyon settled 79 individual claims from Griffin et al. Lyon reported the money was substantial, but less than what they had sought. Sam Austin would get compensation, but instead of an awarded sum, he would be pitted against the other plaintiffs in determining shares of a finite pot. MRL attorney Cox said the Austin jury decision was key to settling the cases. Cox lectured in the Missoulian, "I think that the defense verdict in the Austin case had the effect we thought it would, to maybe change the view of a number of people with claims remaining to think maybe that what they should be focusing on was a fair and reasonable settlement instead of perhaps their chance to win the legal lottery." Lyon blamed various federal and court rulings for hurting the cases and reiterated that U.S. Magistrate Erickson's jury instruction to not allow Warren Rail to be a determiner of negligence had hurt them badly. "That was our whole case," he told the paper. Lyon said that in hindsight, the only different strategy he would have used would have been to try the case elsewhere if possible. "I have tried cases against Ford Motor Company, General Motors, and some of the biggest oil companies in the United States, and it's harder to beat Montana Rail Link in Missoula, Montana, than it is to beat any of those guys anywhere else," he told the paper. It's true. Lyon never appealed on liability claims, implying the multi-year wait was too long. The 2002 Walsh's trial, which awarded only damages, ended litigation. John Hart thought MRL's attorneys did a hell of a job finding experts and working with experts and paying them over $1 million in order to come to the conclusion that there was some non-bonded area within this rail that was undetectable and undetected for 28 years. And that failed, and the failure was unrelated to railware. I mean, it was really an amazing thing, and the jury believed them. They just kept pumping money into their experts until the experts finally came up with some kind of defensible and credible theory, Hart said. A theory that worked. MRL's legal defense was recognized in 2001 by the National Law Journal, which listed Austin v. Montana Rail Link as one of the top 20 defense wins in the nation. Randy Cox said that to have the case picked out of thousands of verdicts is professionally satisfying. David Potter basked in the glory. Potter told the National Law Journal, "The art of the win came in convincing the jury that the evidence proved an undetectable internal defect in the rail web caused the accident and was not influenced by rail wear. Rail wear that was never allowed to be evidence. The jury's confusion over awarding damages shouldn't have mattered in determining negligence, and their sympathy for Austin shouldn't have biased their finding of negligence. And ultimately, Austin would get some compensation. The actual express bias seemed technical. Plaintiffs were hamstrung on presenting issues of rail wear and A-rail, coupled with lack of FRA regulation regarding many railroad standards. Under those railroad house rules, MRL had won the game. Next time on Gas, the true story of a toxic train derailment, insiders at Montana Rail Link reflect on the railroad's operations after they have been found not negligent for the Alberton derailment. Until then, this is Ron Scholl. Thanks for listening. This podcast is adapted from the book Gas, the true story of a toxic train derailment. Visit Amazon.com to see the 2-book series. To access support material in the book, such as maps, photos, illustrations, and video links, visit my Facebook page Gas, the true story, or watch my Gas playlist on my YouTube channel at RL Scholl.